Teresa, it is wonderful to have you here with us to share about how you have worked on the life issue for so long, to tell us about your journey, not only as a professor, but as a litigator, as someone who's testified in Congress. So those are some things we can talk about today. But first, tell us about what you're doing now. You're at the University of St. Thomas, directing the Prolife Center. I'd love to hear more about the work of the Prolife Center and help other people that are watching this video understand more about the important work that you're doing at the university.
Well, Renee, I'm absolutely delighted to be here, and I've got to say, for anybody viewing this, that Renee is one of our most talented graduates, that she has had already at her young age a distinguished career in public policy and in law, and we are blessed by the efforts that she's making. And we've actually worked together. We worked together recently on a brief to the United States Supreme Court on behalf of advancing American values that former Vice President Pence founded in order to really fight for the things that Americans care about. And the brief talked about the context of Roe v. Wade and how it has led to the unraveling of the family and a lot of other important issues, the unraveling of romantic relationships between men and women. And all of that is collateral damage to the fact that we've literally lost millions of tiny children to the scourge of abortion. So it's great to be with you today. It's great to continue to collaborate with you. At the Prolife Center, that is in fact what we are chartered to do. We are a university-approved center. The university provides no resources other than resources in kind. In other words, I'm allowed to use the classrooms for free, I'm allowed to use their technology for free, but there's no financial support for the Prolife Center. And on that, we rely on donors to pay for things like the printing costs for our amicus brief to the United States Supreme Court. In Dobbs, I actually was lead counsel on a brief for 280 women.
Yes, you were.
And Governor Kristi Noem was our lead on that, our lead amici. And so that brief argued that, in fact, abortion does not advance the interest of women. That's one of the lies that's been told by the abortion industry long before 1973 with Roe versus Wade. But in 1973, the Supreme Court of the United States wrote it into law. It was several decades after that that the Minnesota Supreme Court wrote into our law a belief that abortion is a fundamental right. Now, I think it's important for people watching this video to understand that in that particular case, Doe v. Gomez,
That's right, okay.
the Attorney General for the state simply did not contest whether the state constitution had a right to abortion inherent in it. And the simple fact is there's nothing in Minnesota history.
That's right, nothing in the Constitution explicitly, nothing in Minnesota history. So where did they get this idea that somehow we have a fundamental right to abortion in Minnesota in the Doe v. Gomez case?
It was really a very odd case. It was a case in which a group of women and members of the abortion industry, doctors, clinics, wanted to ensure government funding for abortion, something that the United States Supreme Court rejected a few years earlier before Doe v. Gomez. And in that case, in what I think is just a remarkable failure to represent the interests of the people. Again, the government was the defendant. The state attorney general was the lawyer for the state of Minnesota. And he simply conceded that there was this right to abortion written into the Constitution, and the only thing that the court really needed to confront was whether or not that right had to be funded, the exercise of that right had to be funded through state funds. What's really interesting about that is we have lots of rights that under the state constitution, authentic rights, like the right to religion that's explicitly within the text. The government's not obligated to fund the repairs on the cathedral or the building of a new church or pastors' salaries. Now, colonial times, we weren't a colony, but nonetheless, there were a couple of states where they actually paid pastors' salaries. But that's not true under the First Amendment and not true under the Minnesota Constitution. So this idea that because Minnesota was paying for prenatal care and to assist young mothers, that we necessarily had to pay for the abortion if that was the woman's choice. The majority opinion in that case, and there was an excellent dissent, but the majority opinion in that case said it is false that we're providing funding for abortion on demand for low-income women. In fact, this is only therapeutic abortions. But as you know and I know, and it was said out loud at a recent legislative hearing here in the state, that the Department of Health has taken on the position, Department of Human Services, that any abortion for a low-income woman is therapeutic in nature, and therefore there are no constraints. And the dissent was right. This is abortion on demand paid for by taxpayers.
So, I mean, and you've written about this before, that the abortion industry is treated differently than, even if you wanted to call it a medical service, it's treated differently even within the own sphere of medicine. Can you talk about how abortion is kind of an outlier, maybe even given special privileges in some circumstances?
Oh, there's no question. And in fact, at another hearing this legislative session, the CEO of Planned Parenthood admitted, upon questioning by one of the legislators, that abortion clinics are completely unregulated. Nail salons are regulated in this state. I can't go get a manicure without it being subject to regulation by the health department. And yet abortion clinics are not. And so we see the sort of abuses that were found, at least in other states, like Kermit Gosnell, who was actually, after killing a number of women and babies, was convicted of murder because he was completely unregulated. Now, that case is particularly egregious because the clinics were supposed to be regulated. And the governor said, well, that's a barrier to women's access, so we're just not going to enforce those laws. Here, we don't even have regulations, so they're not even put to that problem. We do have other types of regulations, like a requirement that where a young girl is seeking an abortion, that both parents have to be notified. Now, there's some exceptions. If the young girl says that she's the victim of abuse, notification's not required. There are a couple of other exceptions. But in that instance, the Attorney General, in a recent case called Doe v. Minnesota,
I'm glad you got to this.
in a recent case called Doe v. Minnesota, the Attorney General's office filed what's called an affidavit or a declaration. In other words, it's a sworn statement that the Attorney General's office has never enforced any of the limitations of an abortion in this state, nor have they investigated them. And so it's really, it explains to some degree why Minnesota is an abortion destination. We are providing abortions that other states have said are unsafe for women, that the child is developed enough that we will not tolerate a direct attack on his life, which is exactly what abortion is. And the Attorney General for the state now and the governor have both announced that they want to increase our abortion tourism, that we want to make sure that we can attract women from all over the country and even pay for their abortions and time off while they're getting their abortions and traveling. And it really...
and really up the ante now that we're surrounded in the Midwest by many states that are the exact opposite, or that see that abortion isn't an answer to women's problem or family flourishing at all. We will be an outlier if the legislation that you've referred to, that we can talk more about in a little bit, if that actually passes. We will be one of the most extreme abortion states in the country, abortion destination. Using taxpayer money for abortions is just astounding. And this is so inconsistent, as we know, with 70% of Minnesotans. They do not want a radical overhaul of the protective laws with respect to abortion.
Well, actually, there are two paths to that dreadful future. And as I mentioned, I'm representing a group, Mothers Offering Maternal Support, in Ramsey County, which is where St. Paul is. I actually represent the organization itself.
That's right.
So, and the organization is limited to Minnesota moms who have minor daughters. That's daughters under the age of 18. That is something that viewers of this, if they are Minnesota moms with young daughters, they absolutely should learn more about Mothers Offering Maternal Support. These brave ladies in this Minnesota case learned that the district court in Ramsey County had struck down basically all the Minnesota laws regulating abortion on the request of an abortion doctor, a nurse who wants to provide abortions, and a private abortion funding. In this instance, what the court did is it had these plaintiffs come in and they challenged parents' right to be notified if their minor daughter's having an abortion. The plaintiffs challenged whether abortions should be performed by physicians or physicians in training. They wanted to open it up to any, and it's unclear. It looks like when they say healthcare practitioner, that definition could include podiatrists, opticians. So it's not at all clear what the limitations are. And then they also wanted to eliminate any felony criminal penalties. They wanted to eliminate mandatory reporting on injuries that are suffered during abortions or just the basic demographic characteristics of the women obtaining abortion. Now, this is regular data that the state collects in all sorts of settings to make sure that the healthcare system is working correctly. And I'm not suggesting that I think the abortion industry is part of the healthcare system, but that is the premise of the abortion industry and their advocates. And so just basic data, how many abortions are occurring in the state? How many abortions are occurring weeks 20 forward? How many gestation? How many abortions are we performing that are medical or chemical abortions with the drugs? How many abortions are we performing that have surgical requirements? But it's an important thing to know. And this idea that the vast majority of abortions are because women have health issues, it's just not borne out by the reasons that are given to the Minnesota Health Department. We need to know that. We need to know how to provide assistance so that families can flourish, as you said. Yet there's a bill going through the legislature right now that I've testified on, and you have too, several times, where the proponents of this bill, the folks trying to pass this bill, say, well, this data can be accessed by abortion researchers or healthcare researchers. What they really mean is that Planned Parenthood can publish what they want to publish, but someone like myself who wants to go in and look at the data will have zero access. Zero access. Without the requirement that they provide this data to the government, anybody that disagrees with their agenda will be denied access, and we've seen that time and time again.
Yep, you've also written on that too, the inaccuracies of the reporting data and just the inaccessibility of even getting this data, and so we can't have a compare and contrast because we don't really have a full slate of data in front of us.
Right,
So I think that's extremely problematic.
The New York Times has been heralded, and we had to deal with it in our Supreme Court briefs. A study out of that was driven through California called the Turnaway Study that supposedly proves that women suffer tremendous ill effects if they are turned away from an abortion economically, their lives become chaotic, et cetera. Well, number one, they won't release the raw data to anyone outside of their authors or someone sympathetic to the industry. So there's no way to get access to look. Number two, even as they report it, the number of women, it was supposed to be a longitudinal study, the number of women who were recruited and who initially accepted the invitation to participate dropped off dramatically. And so their sample size gets smaller and smaller and smaller. Right. They don't have access to the economic information that they, speculate would be the outcome.
But yet we're making these critical policy decisions based on, as you said, narrower data.
To read the Star Tribune story about it or the New York Times story about it, you'd think that this was, gold-plated research, and it's absolutely not. And even the abortion industry, in its more honest moments, admits that the data is problematic. The best data we can get on abortion, frankly, is coming out of Europe.
We've got these laws that have passed. Some people might know the name Senate File 1 and House File 1, which were intentionally named as the number one priority to create a fundamental right to abortion here. And then we've got this other Doe v. Minnesota case that is trying to really ramp up the Doe v. Gomez decision. So not only a fundamental right to abortion, but repealing all of the health and safety protections. And then enter moms, where this group of moms says, this isn't okay. I have fundamental rights here. I'm a parent, and I can't imagine that, as you said, my daughter can't get her ears pierced. She can't go on a field trip, but she can get an abortion, and I won't know about it. And the complications that could result from that are just incredible. And what is a parent to do? They might think that their daughter's just, maybe having a bad period when in fact she's had an abortion without their knowledge. Who's going to advocate for her? So you're representing this group of moms that is in the courts trying to intervene, and maybe you can explain more about what that looks like, trying to enter this lawsuit to have these rights vindicated. And maybe you can talk about what that might hopefully do with respect to the laws that we know that are in question right now. Will that restore them? And how does this all piece together? Because there's a lot going on in our state.
Sure. Well, as I mentioned, this abortion doctor and a nurse who wants to do abortion in this abortion funding group came in to challenge these laws 3 years ago.
Yes.
And fairly quickly after that, a couple of organizations, Prolife Action Ministries came in and said, we've been involved. They also want to get rid of the fetal disposition law, the law that requires that when an abortion's been done, that the baby either be buried or incinerated, which actually is critical given that we know that there is an industry in aborted fetal baby parts. We know that the University of Minnesota participates in that. I've seen an invoice where they were ordering an organ that had to be at least 16 weeks or older in gestational stage. So Pro-Life Action Ministries came in and said, we'd like to help defend this law. The Attorney General said, I don't need any help. And the judge said, the Attorney General's doing fine, and no, we're not going to let you in the case.
So these plaintiffs sued the state. The Attorney General is supposed to defend the laws that are on the books, which would include ones that you just talked about: parental notification, informed consent, waiting periods, hospitals,
mandatory reporting,
physician only, all these things that we think are just consumer protections, basically.
Right.
We wouldn't agree that abortion is healthcare, but we would at least want some safeguards around it like any other part of the medical industry. So the Attorney General is tasked with defending those, and you're saying that these groups like Pro-Life Action Ministry have said, wait a minute, we don't think you're doing that, so we need to be a part of this lawsuit.
And I think they also said, independent of whether you're doing it, two heads are better than one.
True.
Let us in. We've got a very talented lawyer, a lawyer who had gone all the way up to the United States Supreme Court and won. And the judge said no, because both the plaintiffs and defendants, and that ought to tip people off, both the plaintiffs and defendants said, no, we don't want anybody else to play. So then the Minnesota Senate, when it had a Republican majority, and this shouldn't be a partisan issue, so please, but the Republican majority, they said, well, we want to come in and help defend the laws that we passed. And again, the judge said, I think the Attorney General is doing a fine job. Both plaintiffs and defendants objected, and so the judge said, no, you have no evidence that he's done anything wrong. Well, fast forward 3 years, and the judge's opinion comes down, it strikes down parental involvement, it strikes down the hospitalization requirement, it strikes down physician only, waiting periods, informed consent. It does leave intact the majority of the mandatory reporting law, okay? It's an 80-page opinion on Westlaw, and it's a complex opinion. It's clear that the judge spent a lot of time thinking about this, but frankly, because of the conduct of the Attorney General and the governor and the state officials in this case, his hands were tied. Not once, not twice, 12 times in the opinion, the judge says, defendants presented no evidence, defendants presented no evidence, defendants presented no evidence. Or he says, plaintiffs' unrebutted evidence, which to non-lawyers means defendants presented no evidence.
So there was nothing for him to rely on to determine that perhaps the laws are constitutional. That you're saying that any of the evidence, which would be expert opinions that the Attorney General had submitted to defend the laws, were essentially deficient.
That's exactly right. The plaintiffs in this case came in and made statements that, having done abortion litigation for years, I was Special Assistant Attorney General for Oklahoma. I represented all of the state district attorneys in Kansas in a case regarding abortion. You come to expect that the abortion industry is going to say that abortion is great and there are no adverse consequences and parents are evil, or if they're not evil, the girl's going to tell them anyway, so you don't need this law, and that no girl's ever sexually abused by an adult. And I mean, they make these claims like the one they made in this case, which is that teenagers have the exact same decisional capacity as adult women. The whole legal setup it denies this. We have juvenile justice courts because the U.S. Supreme Court has declared, consistent with the facts, that teenagers are impulsive. They do not have the same decision-making capacity that adults do. And yet the Attorney General filed no evidence disputing that.
So as you're saying, there's no evidence presented in this case to defend the parental notification law, despite the fact that the entire legal system is set up to protect minors from being vulnerable and making these impulsive decisions. We know that parents have the best interests of their children in mind. And in fact, we know that the Minnesota legislature recognized that when they passed the parental notification law with bipartisan support. So to me, I've been watching this case and I've just been astounded that there's even a challenge to a law that was supported by majority of Minnesotans.
This is a case where the Attorney General, because he provided no evidence, never went to trial. The last time our parental notice laws were at issue, it was then Attorney General Hubert Humphrey. There was a 5-week trial just on parental notice. It was vigorously defended. He took it all the way up to the U.S. Supreme Court, and he won. This Attorney General provided 2 expert reports, not even affidavits, not even declarations, nonetheless, one of which said none of these laws have any effect. Same number of girls are getting an abortion, so you can't say it's a real problem for anybody. That was their big defense. Or, well, the U.S. Supreme Court has already upheld these. States are free to interpret their constitution differently than the federal constitution. And in Minnesota, that's exactly what the Minnesota Supreme Court did in Doe v. Gomez. The defense is completely deficient. And so we are trying to intervene. We have asked the court to let us in. Once again, both the plaintiff and the defendant are objecting and saying that we're too late to the party, that the case was adequately defended, that it would create too big a burden on the plaintiff to actually have to defend the case as it should have been done. And we had a hearing early January. The judge has 90 days to issue a ruling. The hearing went for 2 hours. It was open to the public via Zoom. It was a vigorous inquiry by the judge. He asked lots of good questions, lots of important questions to both sides. I'm guardedly optimistic. Lawyer learns quickly never to say for sure what a judge is going to rule. But the simple fact is that this representation on the part of the defendants was basically not representation. And these Minnesota moms have a statutory right to notice on their daughter's intent, as do their dads. And if we are allowed into the case, we've already presented the judge 10 expert declarations, one of which runs 80 pages. We've done our homework. We're ready to defend these laws.
So we have these kind of, like I said, concurrent tracks where we've got things going on at the courts, but then while we have this case that we're awaiting the judge's decision, we've got things happening at the legislature where they've passed, as we referenced earlier, Senate File 1 and House File 1, this fundamental right to abortion. And then we have the Senate File 70 and House File 1, which I've called the how-to bill, which is, the mechanics of how do we give a fundamental right to abortion? What do you think might happen? My understanding of Doe v. Gomez is that it never said that abortion cannot have some regulations and parameters, just like any other, quote, medical care, which I don't think abortion is medical care, but if we're treating it as such, it's regulated, hopefully, like any other medical procedure.
And there are huge concerns. It puts young girls at risk. In Minnesota, I was shocked to learn that the Twin Cities is 13 in the nation in child prostitution. 13, okay? We're 3rd in human trafficking. So there are young girls out there, there are adult women out there that are being coerced to have sex, that become pregnant, and those who have coerced them are demanding that they get an abortion. Without these protections of informed consent, a reflection period, parental involvement, we will not be able to fight the scourge of these sorts of sex crimes. And it's astonishing to me that this is something that Iron Range Democrats are being bullied into voting for. I mean, these are common sense protections, and as you noted earlier, historically, Republicans and Democrats can come together on some of these things. And as far as the fundamental right, the U.S. Supreme Court, even under Roe v. Wade, said parental involvement is constitutional with certain limitations. They upheld informed consent. They upheld reporting requirements. They upheld pretty much everything that this district court struck down, not necessarily because the judge was persuaded that's what the law meant, but because the government officials didn't present a defense. Right. I get a little worked up about this.
No, Teresa, I'm so glad you came in today. Thank you so much for sharing your wealth of knowledge. I appreciate all of your work on the front lines in the court, testifying at the legislature. It is just really invaluable, all of your experience and just your care. I know that you're not doing this because it's just, it is fun for you academically, and I know that it stimulates your mind, but I know that you really have a love for women and for children and for flourishing families, and I really admire you for that. I'm thankful to be your friend, and I'm thankful for our relationship. We've really been able to rally around some important issues in our state, so thank you again for coming, and appreciate all that you're doing here on the front lines in Minnesota.